Good morning, class. Our topic for today is about elective officials, qualifications, disqualifications, and vacancies. Now, qualifications prescribed by law for public elective position in the Philippines are continuing requirements and must be possessed for the duration of the officer's active tenure. It is the Philippine Congress which has the power to prescribe additional qualifications and disqualifications. Let's talk about qualifications. This is found in Section 39 of our Local Government Code of 1991. Letter A, an elective local official must be a citizen of the Philippines, a registered voter in the barangay, municipality, city or province, or in the case of a member of the Sangguniang Panlalawigan, Sangguniang Panglungsod, or Sangguniang Bayan, the district where he intends to be elected, a resident therein for at least 1 year immediately preceding the day of the election, and able to read and write Filipino or any other local language or dialect. Letter B, candidates for the position of governor, vice governor, or member of the Sangguniang Panlalawigan, or mayor, vice mayor, or member of the Sangguniang Panglungsod of highly urbanized cities must be at least 23 years of age on election day. Letter C, candidates for the position of mayor or vice mayor of independent component cities, municipalities must be at least 21 years of age on election day. Letter D, candidates for the position of member of the Sangguniang Panglungsod or Sangguniang Bayan must be at least 18 years of age on election day. Letter E, candidates for the position of punong barangay or member of the Sangguniang Barangay must be at least 18 years of age on election day. And letter F, candidates for the Sangguniang Kabataan must be at least 15 years of age, but not more than 21 years of age on election day. So take note, class, that the qualifications of the elective officials that does not say kinahanglan nga naamoy nahuman nga kurso, no? So if you try to look at letter A, ang iyaharag yung qualification din ha is able to read and write Filipino or any other local language or dialect. So walay educational qualification nga hatag or prescribe ang atong local government code. Okay? Now, let's talk about citizenship. While certain national officials like the president, vice president, members of Congress, etc., must be natural born Filipinos, local elective officials need not be natural born. Okay, so it is sufficient that they are citizens of the Philippines. Thus, a foreigner who has been validly naturalized may be qualified to a local elective official. A natural-born Filipino is one who became such without having to perform an act in order to acquire or perfect citizenship. An interesting question was resolved by the Supreme Court in the landmark case of Privaldo versus Comelec. Now, in this case, class, after having been declared earlier as a non-citizen, Privaldo applied for repatriation on August 17, 1994. It was immediately processed and granted as the Committee on Naturalization was made inactive at the time. When Privaldo filed his certificate of candidacy for the May 1995 elections, his applications for repatriation remained pending. Privaldo was, however, overwhelmingly elected governor of Sorsogon by a wide margin of 20,000 against his opponent. Now, at this time, his application remained pending. Okay, so at 2 o'clock in the afternoon on June 30, 1995, however, Privaldo's application for repatriation was approved and completed. Now, it was argued that Privaldo should have already possessed the citizenship qualification at least on the day he was elected. It was held that the citizenship qualification under Section 39 of the Local Government Code of 1991 was for elective officials, not for candidates. It was also held that the repatriation of Privaldo retroacted to the date of the filing of his application on August 17, 1994, such that at the time of the filing his certificate of candidacy and at the time he was overwhelmingly elected governor, he was deemed to have already reacquired his Filipino citizenship. Also, read this case class, the case of Privaldo versus Comelec, GR number 120295. Okay, para na amoy idea o unsay nahitabo ani nga case in relation to citizenship as one of the qualification to run for office o local, no, local office. Okay, so let's proceed to the requirement of residency. Okay, so residence in its ordinary conception implies the factual relationship of an individual to a certain place. It is the physical presence of a person in a given area, community, or country. The essential distinction between residence and domicile in law is that residence involves the intent to live when the purpose for which the resident has taken up his abode ends. One may seek a place for purposes such as pleasure, business, or health. If a person's intent be to remain, it becomes his domicile. If his intent is to leave as soon as his purpose is established, it is residence. It is thus quite perfectly normal for an individual to have different residences in various places. However, a person can only have a single domicile unless, for various reasons, he successfully abandons his domicile in favor of another domicile of choice. Now, take note that there is a difference between domicile and residence. When we talk of uh, residence, it is used to indicate a place of abode, whether permanent or temporary. Domicile denotes a fixed permanent residence to which, when absent, one has the intention of returning. A man may have a residence in one place and a domicile in another. Residence is not domicile, but domicile is residence coupled with intention to remain for an unlimited time. A man can have but one domicile for the same purpose at any time, but he may have numerous places of residence. His place of residence is generally his place of domicile, but it is not by any means necessarily so, since no length of residence without intention of remaining with constitute um, will constitute domicile. For political purposes, the concept of residence and domicile are dictated by the peculiar criteria of political laws. As these concepts have evolved in our election law, what has clearly and unequivocally emerged is the fact that residence for election purposes is used synonymously with domicile. Now, indeed, the term residence, as used in the election law, is synonymous with domicile, which imports not only intention to reside in a fixed place, but also personal presence in that place, coupled with conduct indicative of such intention. Take note, class, that the manifest intent of the law in fixing a residence qualification it is to exclude a stranger or newcomer unacquainted with the conditions and needs of a community and not identified with the latter from an elective office to serve that community. The Constitution and the law requires residence as a qualification for seeking and holding elective public office in order to give candidates the opportunity to be familiar with the needs, difficulties, aspirations, potentials for growth, and all matters vital to the welfare of their constituencies. Likewise, it enables the electorate to evaluate the office seeker's qualification and fitness for the job they aspire for. Thus, establishing residence in a community merely to meet an election law requirement defeats the purpose of representation, to elect through the assent of voters those most cognizant and sensitive to the need of the community. This purpose is best met by individuals who have either had actual residence in the area for a given period or have been domiciled in the same area for a given period or who have been domiciled in the same area either by origin or by choice. Uh, okay, take note of that, class. In Torino case, class, Torino versus Comelec, it was held that it is inasmuch as Vicente Y. Imano has proven that he, together with his family, number one, had actually resided in a house he bought in 1973 in Cagayan de Oro City. Number two, had actually held office there during his 3 terms as provincial governor of Misamis Oriental, the provincial capital being located therein. And number three, had registered as voter in the city during the period required by law. He could not be deemed a stranger or newcomer when he ran for and was overwhelmingly voted as city mayor. Um, Election laws must be liberally construed to give effect to the popular mandate. In other words, the actual physical and personal presence of Vicente Y. Imano in Cagayan de Oro City is substantial enough to show his intention to fulfill the duties of mayor and for the voters to evaluate his qualifications for the mayorship. Petitioner's very legalistic, academic, and technical approach to the residence requirement does not satisfy the simple, practical, and common sense rationale for the residence requirement, said the Supreme Court. Now, a domicile of origin is acquired by every person at birth. It is usually the place where the child's parents reside and continues until the same is abandoned by acquisition of a new domicile or the domicile of choice. So, read the case of Torino versus Comelec, GR number 137329, August 9, 2000. No, para makasabtan ninyo ang concept sa residence. Plus the case of Coquilla versus Comelec, GR number 151914. Now, in Coquilla versus Comelec class, petitioner therein, born of Filipino parents, joined the United States Navy and was subsequently naturalized as U.S. citizen. Later, he applied for repatriation and consequently took his oath as a citizen of the Philippines. When his residence was questioned, it was held that he lacked the requisite residency to qualify him for the mayorship of Oras, Eastern Samar. It was held that petitioner therein lost his domicile of origin in Oras by becoming a U.S. citizen after enlisting in the U.S. Navy. From then on and until the time when he acquired Philippine citizenship, petitioner was an alien without any right to reside in the Philippines, serve as the immigration laws may have allowed him to stay as a visitor or as a resident alien. Now, in order to acquire a domicile by choice, there must concur number one, residence or bodily presence in the new locality. Number two, an intention to remain there. And number three, an intention to abandon the old domicile. In other words, there must be an animus non revertende and animus manende. Now, animus non revertende is with no intention of returning, and animus manende is intention of remaining or intention to establish a permanent residence. The purpose to remain in or at the domicile of choice must be for an indefinite period of time. The acts of a person must conform with his purpose. The change of residence must be voluntary. The residence at the place chosen for the domicile must be actual, and to the fact of residence there must be added the animus manende, or the intention to establish a permanent residence, or the intention of remaining on that place. Mere absence from one's residence or origin, domicile to pursue studies, engage in business, or practice a vocation is not sufficient to constitute abandonment or loss of such residence. So, the determination class of a person's legal residence or domicile largely depends upon intention, which may be inferred from his acts, activities, and adherences. Okay, so the party who claims that a person has abandoned or left his residence or origin must show and prove preponderantly such abandonment or loss. Okay, so dili pwede i-prove jud nila nga tinuod nga gi-abandon na niya ang iyahang domicile of origin. Okay? A citizen may leave the place of his birth to look for greener pasture, as the saying goes to improve his life, and that of course includes study in other places, practice of his vocation, or engaging in business. So, when an election is to be held, the citizen who left his birthplace to improve his lot may desire to return to his native town to cast his ballot, but for professional or business reasons, or for any other reason, he may not absent himself from the place for any other reason. He may not for professional or business activities, so there he registers as voter, as he has the qualifications to be one and is not willing to give up or lose the opportunity to choose the officials who are to run the government, especially in national elections. Despite such registration, the animus revertendi to be his home, to his domicile or residence of origin, has not forsaken him. Okay, so while citizenship may be possessed even on the day the candidate assumes office, presidency under Section 39, Paragraph A of the LGC of 1991 requires that the candidate must have been a resident of the locality concerned for at least 1 year immediately preceding the day of the election. So take note of that, class. Okay. We have here a table, qualification to hold public office. Okay, so president, no, natural born uh, citizen of the Philippines, a registered voter, able to read and write, at least 40 years of age of the day of election, resident of the Philippines for at least 10 years immediately preceding the election. Now, for Vice President, natural-born citizen of the Philippines, registered voter, able to read and write, at least 40 years of age on the day of election, resident of the Philippines for at least 10 years immediately preceding the election. Okay, for senators, natural-born citizen of the Philippines, at least 35 years old on the day of the election, able to read and write, registered voter, resident of the Philippines for not less than two years immediately preceding the day of the election. For congressman, district representative, natural-born citizen of the Philippines on the day of the election, at least 25 years old, able to read and write, registered voter in a district in which he shall be elected, resident thereof, a period for not less than 1 year immediately preceding the day of the election. Now, take note, class, based on the table, there is no educational qualification for you to be able to run or to hold public office. No? So, wala may gibutang diha sa president o may giingon, kinahanglan graduate ka 4-year course or kinahanglan PhD ka or kinahanglan lawyer ka. No? Wala. Even, sa president, sa vice president, senators, and congressman. So, ang pinaka minimum qualification na diha is able to read and write, no? So pwede tang mangdagan og president ani basta moabot tag 40 years old, no? No. Ingana ka interesting ang atong um, panggobyerno class. Wala gid naghatag og educational qualification, no, para makahold og public office. Okay. In party list representative or sectoral representative, so natural born citizen of the Philippines, able to read and write, registered voter, resident of the Philippines for a period not less than 1 year immediately preceding the day of the election, a bona fide member of the sector he seeks to represent, on the day of the election is at least 25 years old, but in case of youth sector representative, at least 20 years and not more than 30 years old in the day election. So, take note class sa kaning party list representative or sectoral representative. Number 5 is a bona fide member of the sector he seeks to represent. So, dili pwedeng magpa-elect ka sa party list representative if you are not a member of the sector he seeks to represent, no, or you seek to represent. For example, ari ka unsa man nga ang teacher na party list, no? So og dili ka teacher, ka member ana nga sector, dili ka pwede dili ka pwede mo run, no, as party list representative. Okay. So, in local officials, okay, so take note of the qualification, citizen of the Philippines, no? So, wala gibutang din ha nga kinahanglan natural born citizen. So, it's enough nga citizen ka of the Philippines, not necessarily natural born. So, pwede kung naturalized citizen ka of the Philippines, you can run for local officials. No? On the day of election, at least 23 years old for governor, vice governor, member of Sangguniang Panlaliwigan, mayor, vice mayor, Sangguniang Panglungsod in highly urbanized cities, while at least 21 years old for the said officials in component cities and municipalities, at least 18 years old for members of the Sangguniang Panglungsod, Sangguniang Bayan, and Sangguniang Barangay and Punong Barangay, at least 15 years old and not more than 21 years of age for Sangguniang Kabataan, is able to read and write Filipino or any other local language or dialect, a registered voter in the constituency and the locality, a resident thereof for a period of not less than 1 year immediately preceding the day of the election. So still walay educational qualification, no? Able to read and write ra gihapon. Okay, so let's talk about disqualifications. Okay, under Section 40 of the Local Government Code of 1991, the following persons are disqualified from running for any elective local position. Letter A, those sentenced by final judgment for an offense involving moral turpitude or for an offense punishable by 1 year or more of imprisonment within 2 years after serving sentence. B, those removed from office as a result of an administrative case. Letter C, those convicted by final judgment for violating the oath of allegiance to the Republic. Letter D, those with dual citizenship. Letter E, fugitives from justice in criminal or non-political cases here or abroad. Letter F, permanent residents in a foreign country or those who have acquired the right to reside abroad and continue to avail of the same right after the effectivity of this code. And letter G, the insane or feeble-minded. Okay, so those are the disqualifications to run for elective local position. Now, what does it mean by sentence by final judgment of an offense? Okay, so to be a ground for disqualification, the judgment of conviction must be final and executory. That is, the parties have not anymore elevated the case in a higher court after the lapse of a period to appeal the case. Okay, so there are two kinds of criminal offenses that may disqualify an elective official. Letter A, an offense that involves moral turpitude, and letter B, an offense that carries the penalty of 1 year or more of imprisonment. Now, take note that in the first type of offense, the penalty that the offense carries is irrelevant, and it must not only could be one that involves moral turpitude. So, dili mo matter kung pila ka tuig ang penalty, no? As long as it involves moral turpitude. In the second type of offense, the nature of the offenses is irrelevant as it only requires that the offense carries the penalty of 1 year or more of imprisonment. Okay? Now, take note of that. Okay, so, unsa man di ay ng moral turpitude, ma'am? No? So, moral turpitude has been defined as everything which is done contrary to justice, modesty, or good morals, an act of baseness, vileness, or depravity in the private and social duties which a man owes his fellow man or due society in general. Now, Zari versus Flores is one case that has provided jurisprudence its own list of crimes involving moral turpitude, namely adultery, concubinage, rape, arson, evasion of income tax, barratry, bigamy, blackmail, bribery, criminal conspiracy to smuggle opium, dwelling, embezzlement, extortion, forgery, libel, making fraudulent proof of loss on insurance contract, murder, mutilation of public records, fabrication of evidence, offenses against pension laws, perjury, seduction under the promise of marriage, estafa, falsification of document, and estafa through falsification of public document. So man yung mga moral turpitude uh, under Zari versus Flores case. Now, read class the case of Hanrieder versus Tivera, uh, AMP-05-2026, August 2, 2007, and De La Torre versus Comelec, GR number 121592, July 5, 1996. Okay, so in Hanrieder versus De Vera, and in regarding the conviction of Imelda B. Fortos, Clerk 3, RTC Branch 40, Calapan City, the Supreme Court had characterized violation of BP 22 as a crime involving moral turpitude. In De La Torre versus Comelec, violation of the anti-fencing law was also considered a crime involving moral turpitude. Again, you read these cases para masabtan ninyo ang concept sa moral turpitude. Okay? Okay, so effect of probation on disqualification. Okay, so those who have not served their sentence by reason of the grant of probation, which should not be equated with service of sentence, should not likewise be disqualified from running for a local elective office because the 2-year period of ineligibility under Section 40, Paragraph A of the Local Government Code does not even begin to run. Now, uh, in Dilatory versus Comelec, no, the court pronounced that the grant of probation does not affect the disqualification under Section 40, Paragraph A of the Local Government Code was based primarily on the finding that the crime offensing of which petitioner was convicted involves moral turpitude, a circumstance which does not obtain in this case. The court's declaration on the effect of probation on Section 40, Paragraph A of the Local Government Code ought to be considered an obiter in view of the fact that De La Torre was not even entitled to probation because he appealed his conviction to the regional trial court, which, however, affirmed his conviction. It has been held that the perfection of an appeal is a relinquishment of an alternative remedy of availing of the probation law, the purpose of which is to prevent speculation or opportunism on the part of the accused, who, although already eligible, did not at once apply for probation but did so only after failing his appeal. Okay, take note of that, class. Removed from office as a result of administrative case. In Osorio versus Comelec, the term office was interpreted to mean any office, whether appointed or elective, as the provision states, removed from office without any qualification, applying cardinal rule in statutory construction that when the law does not distinguish, we must not distinguish. Okay? What is important is that the official concerned was removed therefrom as a result of an administrative case during the effectivity of the Local Government Code of 1991. Okay. Convicted by final judgment for violating the oath of allegiance to the Republic. Now, the revised penal code enumerates certain felonies that are considered violation of fundamental laws of the land. It would seem that violations of the oath of allegiance to the Republic consist of these crimes. In any case, it is the nature of the offense that controls whether the crime involved partakes of the nature of violation to the oath of allegiance to the Republic. Okay, dual allegiance. While the Local Government Code of 1991 speaks of dual citizenship as grounds for disqualification, the Supreme Court has, however, interpreted this to mean dual allegiance. Mere possession, therefore, of dual citizenship is not necessarily a ground for disqualification. So, dili na ang nga kung dual citizen ka class, necessarily disqualify na ka in running. So, ang gimin ani sa Supreme Court is dual allegiance, no? So let's distinguish dual citizenship and dual allegiance. Okay, dual citizenship is different from dual allegiance. The former arises when, as a result of the concurrent application of the different laws of two or more states, a person is simultaneously considered a national by the state. For instance, such a situation may arise when a person whose parents are citizens of a state which adheres to the principle of jus sanguinis is born in a state which follows the doctrine of jus soli. Such a person, ipso facto and without any voluntary act on his part, is concurrently considered as citizens of both states. So, for example, class, Filipino citizen, no? Ang kitang mga Filipino citizens, ang atong balaod, ang nag-adhere na sa principle of jus sanguinis. So kung Filipino ka, bisag asa ka mo ianak, no, you are a Filipino citizen. Then mo adto tahayan kamo. Moadto mo og US, no? Ang US nag-follow na sila sa doctrine of jus soli. So not necessarily nga mga US citizen mo, still you are Filipino citizen, ning adto mo dito and then nanganak mo. So automatic ang inyong anak, no, kay ang citizen ang atong balaod mo follow man wherever we go. So yung sanguini Filipino, no, and then nanganak sa US, ang US follows the USOLI, so automatic inyong anak is dual citizen. Okay. Now, considering the citizenship clause, the Article 4 of our Constitution, it is possible for the following classes of citizens of the Philippines to possess dual citizenship. Number one, those born of Filipino fathers and or mothers in foreign countries which follow the principle of jus soli, the one I mentioned earlier. Two, those born in the Philippines of Filipino mothers and the alien fathers if by law of the father's country such children are citizens of that country. And three, those who marry alien if by the laws of the latter's country the former are considered citizens unless by their act or omission they are deemed to have renounced Philippine citizenship. Now, there may be other situations in which a citizen of the Philippines may, without performing any act, be also a citizen of another state. But the above cases are possible given the constitutional provisions of citizenship. Okay, so take note of that. So, dual allegiance, on the other hand, refers to the situation in which a person simultaneously owes, by some positive act, loyalty to two or more states. While dual citizenship is involuntary, dual allegiance is a result of an individual's volition. So, sa dual citizenship class, wa kay kinahanglang buhaton para mahimo kang dual citizen. Here sa dual allegiance, you have to do something, no? With respect to dual allegiance, Section 5, Article 4 of the Constitution provides dual allegiance of citizens is inimical to the national interest and shall be dealt with by law. Okay? As including Section 5, Article 4 on citizenship, the concern of the Constitutional Commission was not with dual citizens per se, but with naturalized citizens who maintain their allegiance to their countries of origin even after their naturalization. Hence the phrase dual citizenship in Republic Act 7160, Section 40, Paragraph D, and in RA 7854, Section 20 must be understood as referring to dual allegiance. Consequently, persons with mere dual citizenship do not fall under this disqualification, unlike those with dual allegiance, who must therefore be subject to strict process with respect to the determination of their status. For candidates with dual citizenship, it should suffice if, upon the filing of their certificates of candidacy, may elect Philippine citizenship to terminate their status as persons with dual citizenship, considering that their condition is the unavoidable consequence of conflicting laws of different states. So, as, as Joaquin G. Bernas, one of the most respected members of the Constitutional Commission, pointed out, dual citizenship is just a reality imposed on us because we have no control of the laws on citizenship of other countries. We recognize a child of a Filipino mother, but whether or not he is considered a citizen of another country is something completely beyond our control. By electing Philippine citizenship, such candidates at the same time forswear allegiance to the other country of which they are also citizens and thereby terminate their status and as dual citizens. It may be that, from the point of view of the foreign state and of its laws, such an individual has not effectively renounced his foreign citizenship. Okay. Fugitives from justice in criminal or non-political cases here or abroad. Okay, so class, the term fugitive from justice refers not only to those who flee after conviction to avoid punishment, but also to those who, after being charged, flee to avoid prosecution. So you read the case of Marquez versus Comelec, GR number 112889, April 18, 1995, and Rodriguez versus Comelec, GR number 120099, July 24, 1996. Now, in Marquez versus Comelec class, it was averred that at the time private respondent filed his certificate of candidacy, a criminal charge against the winning candidate Rodriguez for 10 counts of insurance fraud or grand theft of personal property was still pending before the Municipal Court of Los Angeles Judicial District, County of Los Angeles, State of California, USA. Now, a warrant issued by said court for his arrest, and it was claimed had yet to be served on private respondent on account of his alleged flight from that country. So, flee siya sa US. Incidentally, however, Article 73 of the Rules and Regulations implementing the Local Government Code of 1991 defines fugitive from justice as referring only to a person who has been convicted by final judgment. Now, in this case, the Supreme Court declared said Article 73 as an inordinate and undue circumscription of the law. Here, the Supreme Court, through a separate opinion of Justice Davide, agreed with the contention of the Solicitor General that the term fugitive from justice refers not only to those who flee after conviction to avoid punishment, but also to those who, after being charged, flee to avoid prosecution. Okay. In a later case of Rodriguez versus Comelec, the Supreme Court reiterated the Marquez ruling and also said that the definition of fugitive from justice in Marquez case indicates that the intent to evade is the compelling factor that animates one's flight from a particular jurisdiction. As there can only be an intent to evade prosecution or punishment when there is knowledge by the fleeing subject of an already instituted indictment or of a promulgated judgment of conviction. The Supreme Court added that intent to evade on the part of the candidate must therefore be established by proof that there has already been a conviction or at least a charge has already been filed at the time of flight. Okay, here in Rodriguez, the petitioner was not adjudged fugitive from justice because he arrived in the Philippines from the US on June 25, 1985, while the filing of the case in the US and the issuance of the arrest warrant by the US court was made on November 12, 1985, or almost 5 months after his arrival in the Philippines. The Supreme Court believed that it was impossible for Rodriguez to have known about the felony complaint and the arrest warrant at the time he left the US, as there was in fact no complaint and arrest warrant, much less conviction to speak of yet as such time. Okay, so take note of the term fugitives from justice. Again, it does not only refers to those who flee after conviction, kanang ning kagyo ning layas after conviction to avoid punishment, but also katong mga ning layas to avoid prosecution. Okay. Now, permanent residents in a foreign country or those who have acquired the right to reside abroad and continue to avail of the same right after the effectivity of the local government code of 1991. Now, the qualification set forth in Article 39 of the LGC are meant to be continuing. Thus, if an elected public official acquires permanent residence abroad, he is deemed to have abandoned his residency in the Philippines and must therefore be disqualified to continue to hold public office. It must be noted that a person can only have one domicile at the time. So, na-discuss na nato a while ago. A person who acquires a new domicile necessarily abandons his current domicile. Um, in election law, the term residence is synonymous with domicile. Okay. What about those who became immigrants of foreign countries? No? So, unsaon man ni pag resolve no ng mga immigrants of foreign countries. Section 68 of the Omnibus Election Code covers both permanent residents and immigrants. Thus, any person who is a permanent resident of or an immigrant to a foreign country shall not be qualified to run for any elective office under this code, unless such person has waived his status as permanent resident or immigrant of a foreign country in accordance with the residence requirement provided for in the election laws. Now, Section 40 of the Local Government Code of 1991 does not mention of immigrant, but it is admitted that immigrants come within the meaning of permanent residents in a foreign country or those who have acquired the right to reside abroad. Immigration is the removing into one place from another, the act of immigrating, the entering into a country with the intention of residing in it. An immigrant is a person who removes into a country for the purpose of permanent residence. Now, to be qualified to run for elective office in the Philippines, the law requires that the candidate who is a green card holder must have waived his status as a permanent resident or immigrant of a foreign country. Therefore, his act of filing a certificate of candidacy for elective office in the Philippines did not of itself constitute a waiver of his status as a permanent resident or immigrant of the United States. The waiver of his green card should be manifested by some act or acts independent of and done prior to filing his candidacy for elective office in this country. Without such prior waiver, he was disqualified to run for any elective office. Now, the law has reserved that privilege for its citizens who have cast their lot with our country without mental reservations or purpose of evasion. The assumption is that those who are resident aliens of a foreign country are incapable of such entire devotion to the interest and welfare of their homeland, for with one eye on their public duties here, they must keep another eye on their duties under the laws of the foreign country of their choice in order to preserve their status as permanent residents thereof. Okay, so take note, if you are a permanent resident in a foreign country, you cannot run for an elective office here in the Philippines. Okay, so another disqualification to run for public elective office is the insane or feeble-minded. For obvious reason, a person who is mentally impaired cannot effectively discharge the duties of a public official. Since the qualifications of local elected officials are meant to be continuing, an elected local government official who became insane or feeble-minded only during his incumbency must likewise be disqualified. So bisan pa man dili siya insane when he runs for office, pero while he's sitting no, sa office and he became insane or feeble-minded, then uh, such candidate or such elective official will be disqualified. Okay, okay. So, in general, no, individuals who lack any of the qualifications prescribed by the Constitution or by law for a public office are ineligible or disqualified from holding such office. An appointment of an ineligible or unqualified person is a nullity. Now, check this table, no? Office newly created or the emoluments of which have been increased. So, senator and members of the House of Representatives are prohibited from being appointed to any office which may have been created or the emoluments thereof increased during the term for which they were elected. So note that emolument does not refer to the fixed salary alone but includes such fees and compensations which the incumbent is entitled to receive by law. Now, being an elective official, so no elective official shall be eligible for appointment or designation in any capacity to any public office or position during his tenure. This is under the Constitution, Article 9B, Section 7. Note that elective official must forfeit his seat if he decide to accept appointment in another public office or position during his term. So, dili pwede nga maglingkod siya as elective official and then mag-hold po siya o another position or public office. Okay, take note. Having been a candidate for any elective position. So no candidate who has lost in any election shall within 1 year after such election be appointed to any office in a government or any government-owned or controlled corporations or in any of its subsidiaries. Now, members of the Civil Service Commission, Commission on Elections, and Commission on Audit are also prohibited by the Constitution to become candidates for any elective position in the elections immediately preceding their appointment. Okay. Under the local government code, the following are disqualified to run for any elective local position. So, ato naman yung na-discuss kaninang 1 to 7, no? Those sentenced by final judgment for an offense involving moral turpitude or for an offense punishable by 1 year or more of imprisonment within 2 years after serving sentence. Those removed from office as a result of an administrative case. Those convicted by final judgment for violating the oath of allegiance to the Republic. Those with dual citizenship, fugitive from justice in criminal or non-political cases here or abroad, permanent residents in a foreign country, or those who have acquired the right to reside abroad and continue to avail of the same right after the effectivity of this code, and insane or feeble-minded. Now, with respect to the appointment of elective and appointive local officials and candidates who lost in an election, the code provides that they cannot, within 1 year after such election, be appointed to any office in a government or government-owned or controlled corporations or in any of its subsidiaries, except losing candidates in barangay election. Okay, so kung sa barangay election na, pwede ra sila ma-appoint. Okay? Mental or physical incapacity. Okay. An idiot or other person, non-compos mentis, is incapable of accepting or holding public office. The law may expressly require that a public officer be in a possession of his mental faculties. Now, misconduct or crime. Persons convicted of crimes involving moral turpitude are usually disqualified from holding public office. The provision of a statute prohibiting convicted persons from qualifying for office promote honesty and integrity in candidates for and holders of public office. It is it has been held that the legislative requirement that the person must have no criminal record in order that he may qualify for appointment was not intended to automatically cover every violation of municipal or city ordinance, carrying a sanction to a minimal fee to enforce it. A violation of a municipal ordinance to qualify as a crime must involve at least a certain degree of evil doing, immoral conduct, corruption, malice or want of principles reasonably related to the requirements of public office. Now, impeachment. Okay? The president, the vice president, the members of the Supreme Court, the members of the constitutional commissions, and the ombudsman may be removed from office on impeachment for and conviction of culpable violation of the Constitution, treason, bribery, graft, and corruption, other high crimes, or betrayal of public trust. This is enunciated in Article 11, Section 2 of the 1987 Philippine Constitution. Now, judgment in cases of impeachment is limited to removal from office and disqualifications to hold any office under the Republic of the Philippines. But the party convicted shall be nevertheless be liable and subject to prosecution, trial, and punishment according to law. Now, in removal or suspension from office, the grounds for removal or suspension from office includes acts which would disqualify one from holding office. The law can attach ineligibility to suspension or removal from office, but where there is no constitutional or statutory declaration or ineligibility for such cause, the courts may not impose the disability. Letter A removal from office bars the removed officer from an election or appointment to fill the vacancy for the unexpired term, but it does not disqualify him to make some other office or to be elected or appointed to a new term of the same office. B, if a public officer anticipates his removal for crime of misconduct in office, for crime or misconduct in office, by first tendering his resignation. Even if it is accepted, he is not thereby rendered eligible for election to the vacancy for the balance of the term caused by his resignation to escape expulsion. Now, previous tenure of office. So under the Constitution, a disability to succeed to office is imposed upon certain officers. A, the president is not eligible for any re-election. No? So, usa ra jud na ka-term ng atong president class. A person who has been elected to and has held the office of president is absolutely disqualified for any re-election regardless of the length of time he has served as such. A person who has succeeded as president is disqualified only if he has served as such for more than 4 years. So kung, like for example, ang vice president, like sa katong nahitabo sa ato before nga ni succeed si Vice President Arroyo no ni Estrada. So wala siya na disqualified from running um, as president because wala mo lapas og 4 years man ang iyang pagpuli as president. Okay? So maong na elect ra gyapon siya. Okay? B, the chairman and the commissioners of the Civil Service, Commission on Elections, and Commission on Audit, and the Ombudsman and his deputies are appointed by the President without reappointment. No? So, dili na sila po ma-reappoint balik. Meaning to say, after sila mo-serve sa ilang term, then i-reappoint na po balik. Okay? The Ombudsman and his deputies shall not be qualified to run for any office in the election immediately preceding their cessation from office. So after na sila mahuman sa ilang term, dili po sila pwede mo run dayon for public office. No? Consecutive terms. The Constitution prohibits the holding of of certain elective offices by the same persons for more than a stated number of consecutive terms. So, kanang sunod-sunod, no? The Vice President shall not serve for more than 2 consecutive terms. Voluntary renunciation of the office for any length of time shall not be considered as an interruption in the continuity of the service for the full term for which he was elected. Now, a senator shall not serve for more than 2 consecutive terms. Voluntary renunciation of the office for any length of time shall not be considered as an interruption in the continuity of his service for the full term for which he was elected. A member of the House of Representatives shall not serve for more than 3 consecutive terms. Voluntary renunciation of the office for any length of time shall not be considered as an interruption in the continuity of service for the full term for which he was elected. Now, the term of office for elective local officials, except barangay officials, which shall be determined by law, shall be 3 years, and no such official shall serve for more than 3 consecutive terms. Voluntary renunciation of the office for any length of time shall not be considered as an interruption in the continuity of his service for the full term for which he was elected. So, bisan pag mo resign tayo sila class or i-renounce nila ang ilang office, okay, para moingon sila nga para wala na mo nahuman ang among ika 3 terms kay ning resign ko or ni-renounce na ako akong position or akong office. It does not um, serve as interruption. So, dili gihapon sila pwede basta consecutive ng 3 terms. Now, holding more than one office. Okay, so the state has a legitimate interest in preventing one person from holding multiple public offices. So, dili pwede nga daghan ka, ikaw usa ka public servant or public officer or public official, daghan kang bitbiton, daghan kang i-hold nga office. No? The purpose of the restriction is to prevent offices of public trust from accumulating in a single person and to prevent individuals from deriving directly or indirectly any pecuniary benefit by virtue of their dual position holding. A person who accepts and qualifies for a second and incompatible office is deemed to vacate or by implication to resign from the first office. It is also applicable where the holding of more than one position is prohibited by constitutional or statutory provision, although the second position is not incompatible with the first. Okay, so A. The President, the Vice President, the member of the Cabinet, their deputies or assistants shall not, unless otherwise provided in this Constitution, hold any other office or employment during their tenure. A senator or member of the House of Representatives may not hold any office or employment in a government or any subdivision, agency, or instrumentality thereof, including government-owned or controlled corporations on their subsidiaries during his term without forfeiting his seat. If he accepts any other office or employment during his term, he forfeits his seat. Okay. Letter C, the members of the Supreme Court and of other courts established by law shall not be designated to any agency performing quasi-judicial or administrative functions. A member of the Constitutional Commission shall not, during his tenure, hold any other office or employment. During their tenure, the Ombudsman and his deputies are subject to the same disqualifications and prohibitions as provided for members of the constitutional commissions. Unless otherwise allowed by law or by the primary functions of his position, no appointive official shall hold any other office or employment in a government or any subdivision, agency, or instrumentality thereof, including government-owned or controlled corporations or their subsidiaries. No member of the armed forces in the active service shall, at any time, be appointed or designated in any capacity to a civilian position in the government, including government-owned or controlled corporations or any of their subsidiaries. Okay, so dili pwede nga daghan ka og office nga hold. Okay. Relationship with the appointing power. Now, appointments in a public office should be based solely on merit and fitness in uninfluenced by any personal or filial consideration. Okay, so, but sad to say, this is not our reality. No? The Constitution prohibits the President from appointing his close relatives to high positions in the government. The spouse and relatives, by consanguinity or affinity within the fourth civil degree of the President, shall not during his tenure be appointed as members of the constitutional commissions, or the Office of the Ombudsman, or as secretaries, undersecretaries, chairman, or heads of bureaus of offices, including government-owned or controlled corporations and their subsidiaries. This is under Article 7, Section 13 of the 1987 Philippine Constitution. Now, under the Civil Service Decree, all appointments in the national, provincial, city, and municipal governments, or in any branch or instrumentality thereof, including government-owned or controlled corporations, made in favor or a relative of the appointing or recommending authority, or of the chief of the bureau or office, or of persons exercising immediate supervision over him, are prohibited. The word relative and members of the family are those within the third degree, either of consanguinity or of affinity. The restriction shall not be applicable to the case of a member for any family who, after his or her appointment to any position in an office or bureau, contract marriage with someone in the same office or bureau, in which event the employment or retention therein of both husband and wife may be allowed. So kung na-appoint na siya sa office before pa si Jan na minyo, okay ra na sa class. Okay? Full report of an appointment shall be made to the Commission. It is required that the appointment paper shall be accompanied by a certification of the appointing or recommending authority stating that he is not related to the appointee within the third degree of consanguinity or affinity. Now, the following are exempted from operations of the rules of nepotism: persons employed in a confidential capacity, teachers, physicians, members of the armed forces of the Philippines. Okay. Eligibility for ecclesiastics to a local elective position. Okay. It must be noted, class, um, the provision disqualifying ecclesiastics from holding local appointive or elective positions refers to municipal positions only. Okay, so katong mga pare or pastor, no. Hence, there seems to be no controversy for an ecclesiastic to be elected governor of a province, like in case of Roman Catholic priest Eddie Panililio of Pampanga. Now, read the case of Pamel versus Teleron, GR number L-34854. Okay, so, uh, in this case, manggod class, sa Pamel versus Teleron, uh, it raised the novel question concerning the eligibility of an ecclesiastic to an elective municipal position. Now, private respondent therein, Father Margarito R. Gonzaga, was in 1971 elected to the position of municipal mayor of Albuquerque, Bohol. He was thereafter proclaimed. Now, a suit for quo has been filed for his disqualification based on the old Administrative Code provision, Section 2175, which stated, "In no case shall there be elected or appointed to a municipal office uh, ecclesiastics, soldiers in active service, persons receiving salaries or compensation from provincial or national funds, or contractors for public works of the municipality." Now, after a lengthy and protracted deliberation, the court was divided on the issue. 7 members of the court were on the view that the judgment should be affirmed, as the challenge provision is no longer operative, either because it was superseded by the 1935 Constitution or repealed. The other members of the court were of the view that the overriding principle of the supremacy of the Constitution, or at the very least the repeal of such provision, bars a reversal. Now, the remaining 5 members of the court, Chief Justice Castro, Justices Barrido, Makisiar, Antonio and Aquino, on the other hand, held the position that such a prohibition against an ecclesiastic running for elective office is not tainted with any constitutional infirmity. The vote was thus indecisive. While five members of the court constituted a minority, the vote of the remaining seven did not suffice to render the challenge provision ineffective. Section 2175 of the Revised Administrative Code, as far as ecclesiastics are concerned, was to be accorded respect. It must be noted that the provision disqualifying ecclesiastics from holding local appointed or provision or elective position refers to municipal positions only. Hence, there seems to be no controversy for an ecclesiastic to be elected governor of a province like in the case of the Roman Catholic priest Eddie Panlilio of Pampanga. So, ang kuan ra class, ang ma-disqualify is katong mga pare or pastor nga mo lansar og municipal possessions. But wala na kung kuan na kaning like governor, no? Just like in the case of Panlilio. Now, electoral system. The current electoral system established in the 1987 Constitution has the following characteristics. Okay? Ah, the president and vice president are elected nationally for six-year terms, which no re-election allowed. The national legislature is bicameral, with the lower house of 200 representatives elected in single-member district constituencies for three-year terms, plus sectoral representatives appointed by the president. The 24-member Senate has senators um, elected for six-year terms nationally, half elected every 3 years. Representatives are limited to three terms, senators to two. Now, local government officials are elected to three-year terms with a three-term limit. Senators, congressmen, and local government officials are elected in midterm elections, but during presidential election years, everyone is elected at the same time. The system has been first past the post. Whoever wins the most number of vote, votes wins. The elections are supervised by the Commission on Elections, a constitutionally mandated independent body. Date of elections. Unless otherwise provided by law, the elections for local officials shall be held every 3 years on the second Monday of May. While the Constitution does not expressly state that Congress has to synchronize national and local elections, the clear intent towards this objective can be gleaned from the transitory provisions, Article 18 of the Constitution, which show the extent to which the constitutional commissions, by deliberately making a judgment to the terms of the incumbent officials, sought to attain synchronization of election. This objective behind setting a common termination date for all elective officials, done among others through shortening the terms of the 12 winning senators with the least number of votes, is to synchronize the holding of all future elections, whether national or local, to once every 3 years. This election finds full support, these intentions rather, finds full support in the discussions during the Constitutional Commission deliberation. This Constitutional Commission exchanges read with the provisions of the transitory provisions of the Constitution all serve as patent indicators of the constitutional mandate to hold synchronized national and local elections starting the second Monday of May 1992 and for all the following elections. Although called regional elections, the ARMM elections should be included among the elections to be synchronized as it is a local election based on the wording and structure of the Constitution. Now, as can be gleaned from Section 8 of Article 6, Section 4, Paragraph 3 of Article 7, and um, Section 3 of Article 10 of the 1987 Constitution, the power to fix the date of the election is essentially legislative in nature. Okay? Thus, it was held that COMELEC does not have the power to order special elections. The authority of the COMELEC to postpone elections under Section 5 and Section 6 when there is failure of elections of Batas Pangbansa 881 or the Omnibus Election Code presupposes that Congress by law has already fixed the date of the election and by reason of force majeure, violence, terrorism, and other causes enumerated therein, there is a need to postpone the date of election already fixed by law or schedule a new one where the one fixed by law has not been held. Okay, so dili ang COMELEC ang magbuot kano sa ang election. It's the Congress or the legislative branch. Term of office. Now, um, the term of office of elected officials, except barangay officials, which shall be determined by law, shall be 3 years. No? And no such official shall serve for more than 3 consecutive terms. Voluntary renunciation of the office for any length of time shall not be considered as an interruption in the continuity of his service for the full term for which he was elected. As can be observed, only the term of barangay officials is determined by law. This explains where there were times when barangay officials served for 5 years instead of the usual 3-year term. Okay? RA 8524 in 1998 had set the term of barangay officials to 5 years beginning 1997, while RA 9164 in 2002 fixed it to 3 years. It was in this law also that Congress expressly limited the term of barangay officials to 3 terms only and beginning in 1994. Republic Act 9340 in 2005, however, extended the term of barangay officials, which ended on November 30, 2005 to November 30, 2007. Now, the term of office of all other elective officials has been constitutionally set and cannot therefore be changed by Congress. Okay, the three-term limit rule. A consideration of the historical background of Section 8, Article 10 of the Constitution reveals that the members of the Constitutional Commission were as much concerned with preserving the freedom of choice of the people as they were with preventing the monopolization of political power. Indeed, they rejected the proposal put forth by Commissioner Edmondo F. Garcia that after serving 3 consecutive terms or 9 years, there should be no further re-election for local and legislative officials. Indeed, they adopted the alternative proposal of Commissioner Christian Monsud that such officials be simply barred from running for the same position in the succeeding election following the expiration of third consecutive term. Monsod warned against pre-screening candidates from whom the people will choose as a result of the proposed absolute disqualification, considering that the draft constitution contained provisions recognizing people power. Now, for the three-term rule to apply, the following conditions must concur. That the official concerned has been elected for 3 consecutive terms in the same local government post and that he has fully served the 3 consecutive terms. Okay, so in Borja uh, versus Comelec, private respondent Capco Jr. was first elected as vice mayor, but upon the death of the incumbent mayor, he occupied the latter's post for the unexpired term. He was thereafter elected for two more terms. The Supreme Court held that when private respondent occupied the post for the mayor upon the incumbent's death and served for the remainder of the term, he cannot be construed as having served a full term as contemplated under the subject constitutional provision. According to the Supreme Court, the term served must be one for which the official concerned was elected. It is not enough, therefore, that an individual has served three consecutive terms in an elective local office. He must also have been elected for the same position for the same number of times before the disqualification can apply. The Supreme Court added that a fundamental tenet of representative democracy is that the people should be allowed to choose those whom they please to govern them, such that barring the election of a local official because he has already served three terms, although the first as a result of succession by operation of law rather than election, would therefore be to violate this principle. And in Lunsanida versus Comelec, no, therein, petitioner Lonzanida was elected and served two consecutive terms as mayor of San Antonio, Zambales from 1988 to 1995. He then ran again for the same position in the 1995 elections, won, and discharged his duties as mayor. However, his opponent contested his proclamation before the RTC, which ruled that there was a failure of elections and declared the position of mayor vacant. The Comelec affirmed this ruling and petitioner acceded to the order to vacate the post. During the May 1988 elections, petitioner therein filed his certificate of candidacy for mayor. A petition to disqualify him was filed on the ground that he had already served three consecutive terms. The court ruled, however, that petitioner cannot be considered as have been duly elected to the post in the May 1995 elections, and that petitioner did not fully serve the 1995 to 1998 mayoral term by reason of involuntarily relinquishment of office. The Supreme Court ruled that the two requisites for the application of the three rule term, or rather the three-term rule in this case, were absent. Okay. Question. Um, what if a municipality has been converted into a city? May the municipal mayor who has already served for three consecutive terms run for mayor of the city? Okay, the answer is the fact that the new city acquired a new corporate existence, separate and distinct from that of the municipality, does not mean that for the purpose of applying Article 10, Section 8 of the Constitution, the office of the municipal mayor would now be construed as a different local government post as that of the office of the city mayor. So, dili gusto ingon nga na city na sadya, malahi ang unsa ni personality sa city. Okay? In okay, the interesting ni sa nga kuan class sa kang Latasa kani nga question no na answer ni sa case ni Latasa versus Comelec. Okay? Latasa versus Comelec GR number 154829 December 10, 2008. Okay. In that case, class, petitioner Arsenio A. Latasa was elected mayor uh, of the municipality of Digos, Davao del Sur in the elections of 1992, 1995, and 1998. During petitioner's third term, the municipality of Digos was declared a component city to be known as the City of Digos. On February 28, 2001, petitioner filed his certificate of candidacy for city mayor for the May 14, 2001 elections. He stated therein that he is eligible therefore and likewise disclosed that he had already served for 3 consecutive terms as mayor of the municipality of Digos and is now running for the first time for the position of city mayor. Private respondent Romeo M. Sunga, also a candidate for city mayor in the said elections, filed before the Commission on Elections a petition to deny due course, cancel certificate of candidacy, and or for disqualification against petitioner Latasa. Respondent Sunga alleged that petitioner falsely represented in his certificate of candidacy that he is eligible to run as mayor of Digo City since he had already been elected and served for 3 consecutive terms as mayor from 1992 to 2001. The Supreme Court disqualified Latasa for having served 3 consecutive terms already. Thus, further stated that the fact that the new city acquired a new corporate separate and distinct from that of the municipality does not mean that for the purpose of applying Article 10, Section 8 of the Constitution, the office of the municipal mayor would now be construed as a different local government post as that of the office of the city mayor. The territorial jurisdiction of the city of Digos is the same as that of the municipality. Consequently, the inhabitants of the municipality are the same as those in the city. The inhabitants are the same group of voters who elected petitioner Latasa to be their municipal mayor for 3 consecutive terms. They are also the same inhabitants of whom he held power and authority as their chief executive for 9 years. The court here also stressed that the framers of the Constitution specifically included an exception to the people's freedom to choose those who will govern them in order to avoid the evil of a single person accumulating excessive power over a particular territorial jurisdiction as a result of a prolonged stay in the same office. To allow petitioner Latasa to vie for the position of city mayor after having served for 3 consecutive terms as a municipal mayor would obviously defeat the very intent of the framers when they wrote this exception. Should he be allowed there another 3 consecutive terms as mayor of the city of Digos, petitioner would then be possibly holding office as chief executive over the same territorial jurisdiction and inhabitants for a total of 18 consecutive years, which is the very scenario sought to be avoided by the Constitution if not abhorred by it. No? So, mao ni ang answer sa tubag nga pwede ba makadagan ang municipal mayor who has served 3 terms already sa kung mahimo ang municipal o city. No? So, dili na pwede. In Dizem versus Comelec class, this is a more complicated case. The Supreme Court said that respondent Morales cannot be deemed to have served the full term of 2004 to 2007 because he was ordered to vacate his post before the expiration of the term, and that Morales' occupancy of the position of mayor from July 1, 2004 to May 16, 2007 cannot be counted as a term for purposes of computing the 3 term limit. Indeed, the period from May 17, 2007 to June 30, 2007 served as a gap for purposes of the 3 term limit rule insofar as Morales is concerned, such that the period of July 1, 2007 to June 30, 2010 term was effectively Morales' first term for purposes of the 3 term limit rule. No? Now, Abandonment of an office in order to run for another position, like resignation, is voluntary and does not therefore interrupt the continuity of the full term for which the candidate was elected. This principle was applied in a case involving a punong barangay who was elected as such in 1994, 1997, and 2002, and who was elected as municipal councilor in 2004 in the same barangay where he was punong barangay in 1994, 1997, and 2002. He was disqualified for violating the three-term limit rule. Question. Is the preventive suspension of an elected public official an interruption of his term of office for purposes of the three-term limit rule? Now, according to the Supreme Court, interruption of a term exempting an elective official from the three-term limit rule is one that involves no less than the involuntary loss of title to office, such that an officer who is preventively suspended is simply barred from exercising the functions of his office, but title to office is not lost. Okay. Uh, the case of uh, Alvino versus Comelec, uh, mao ni ang nag-answer class nga ang interruption of a term exempting an elective official from the three-term limit rule is one that involves no less than the involuntary loss of title to office, such that an officer who is preventively suspended is simply barred from exercising the function of his office, but title to the office is not law. So ano naman siya, i-suspend raman, wala sa iyahang title. Okay? So dili maka dili ma-consider nga interruption ang preventive suspension sa three-term limit rule. Okay? Now, holdover principle applicable to barangay officials. Okay. Section 5 of Republic Act 9164 provides that all incumbent barangay officials and sangguniang kabataan officials shall remain in office unless sooner removed or suspended for cause until their successors shall have been elected and qualified. RA 9164 is now the law that fixes the date of barangay and SK elections, prescribe prescribes the term of office of barangay and SK officials, and provides for the qualifications of candidates and voters for the SK elections. Okay. Um, the the application of the holdover principle preserves continuity in the transaction of official business and prevents a hiatus in government pending the assumption of the successor into office. Cases of extreme necessity justify the application of the holdover principle. Okay. Let's proceed to vacancies and succession. Okay. Permanent vacancy. A permanent vacancies in the office of governor, vice governor, mayor, vice mayor, and punong barangay. If a permanent vacancy occurs in the office of the governor or mayor, the vice governor or vice mayor concerned shall become the governor or mayor. If a permanent vacancy occurs in the offices of the governor, vice governor, mayor or vice mayor, the highest ranking sangguniang member, or in case of his permanent inability, the second highest ranking sangguniang member shall become the governor, vice governor, mayor, or vice mayor as the case may be. Subsequent vacancies in the said office shall be filled automatically by the other Sangguniang members according to the ranking as defined by the LGC. If a permanent vacancy occurs in the office of the punong barangay, the highest ranking Sangguniang barangay member, or in case of his permanent inability, the second highest ranking Sangguniang member shall become the punong barangay. Okay? At permanent vacancy arise when an elective local official fills a higher vacant office, refuses to assume office, fails to qualify, dies, is removed from office, voluntarily resigns, or is otherwise permanently incapacitated to discharge the functions of his office. For purposes of succession, ranking in the Sanggunian shall be determined on the basis of the proportion of votes obtained by each winning candidate to the total number of registered voters in each district in the immediately preceding election. Permanent vacancies in the Sanggunian. Permanent vacancies in the Sanggunian where automatic successions provided above do not apply shall be filled by appointment in the following manner. Number one, the President, through the Executive Secretary in the case of Sangguniang Panglalawigan and the Sangguniang Panglungsod of highly organized cities and independent component cities. Two, the Governor in the case of Sangguniang Panglungsod of the component cities and the Sangguniang Bayan. Third, the city or municipal mayor in the case of Sangguniang Barangay upon recommendation of the Sangguniang Barangay concerned. Except for the Sangguniang Barangay, only the nominee of the political party under which the Sangguniang member concerned had been elected and whose elevation to the position next higher in rank created the last vacancy in the Sanggunian shall be appointed in the manner herein above provided. The appointee shall come from the same political party as that of the Sangguniang member who caused the vacancy and shall serve the unexpired term of the vacant office. Fifth, in case the permanent vacancy is caused by a Sangguniang member who does not belong to any political party, the local chief executive shall, upon the recommendation of Sangguniang concerned, appoint a qualified person to fill the vacancy. And six, in case of vacancy in the representation of the youth and barangay in the Sangguniang, said vacancy shall be filled automatically by the official next in rank of the organization concerned. Question. In case of permanent vacancy in the Sangguniang, say in Sangguniang Bayan, caused by the cessation from office of a member who does not belong to any political party, who can appoint the replacement and in accordance with the procedure. Okay? The law speaks of local chief executive as having the authority to make the appointment. Now, the question however here is who is the local chief executive, no? Ingon nga, kinsa ang mo appoint, it's the local chief executive. But the question is, kinsa man is the local chief executive? Now, local chief executive referred to in the law is, refers to the governor. Is it the governor or the mayor? No? So, these questions were answered in the case of Fariñas versus CA class. No? In Fariñas versus Court of Appeals class, the petitioners in Fariñas interpreted Section um, 45, Paragraph A of the LGC of 1991 to mean that it is the governor with respect to vacancies in the Sangguniang Panglungsod of component cities and Sangguniang Bayan, or the mayor with respect to vacancies in the Sangguniang Barangay who has the authority to appoint. Okay, so read the case of Fariñas versus CA, GR number 116763, April 19, 1996, for you to understand kinsa man jud ang gimin aning local chief executive, no, nga naay authority to appoint if there is a vacant position. Okay. Temporary vacancy in the office of the local chief executive. Okay. When the governor, city, or municipal mayor or punong barangay is temporarily incapacitated to perform his duties for physical or legal reasons such as but not limited to leave of absence, travel abroad, and suspension from office, the governor, city, or municipal vice mayor or the highest ranking sangguniang barangay member shall automatically exercise the powers and perform the duties and functions of the local chief executive concerned, except the power to appoint, suspend, or dismiss employees, which can only be exercised if the period of temporary incapacity exceeds 30 working days. Okay. Um, in the case of People versus Bustamante class, the Supreme Court resolved the issue that concerns the authority of a duly elected vice mayor acting as mayor to solemnize marriage. The Supreme Court affirmed the authority of the vice mayor as acting mayor to solemnize marriage, for he discharges all the duties and wields the powers appertinent to said office. No? This instance does not involve a question of title to the office, but the performance of the functions thereunto appertaining by one who is admitted to be temporarily vested with it. Okay. Approval of leave of absence. Okay, so leave of absence of local executive official, elective rather, local elective officials shall be approved as follows. Leaves of absence of the governor and the mayor of a highly urbanized city or an independent component city shall be approved by the president or his duly authorized representative. Leaves of absence of a governor, vice governor, or a city or municipal vice mayor shall be approved by the local chief executive concerned, provided that the leaves of absence of the members of the Sanggunian and its employees shall be approved by the vice governor or city or municipal vice mayor concerned. Leaves of absence of the component city or municipal mayor shall be approved by the governor, and the leaves of absence of a punong barangay shall be approved by the city or municipal mayor, provide that leaves of absence of sangguniang provided that leaves of absence of sangguniang barangay members shall be approved by the punong barangay. Now, whenever the application for leave of absence here in above specified is not acted upon within 5 working days after receipt thereof, the application for leave of absence shall be deemed approved. Okay, so that would be all for this topic: elective officials, qualifications, disqualifications, and vacancies. Thank you for listening.